Continuing from our previous lesson on misrepresentation of material facts, we now turn to a deeper understanding of what specific actions constitute violations of the Arizona Consumer Fraud Protection Act, CFPA, enacted in 1967 and codified under ARS, Section 44-1521 through Section 44-1534. The act was designed to protect Arizona consumers from deceptive, unfair, and fraudulent business practices in all forms of commerce, including real estate transactions. Because real estate often involves complex negotiations, advertising, and representations, the potential for consumer deception is significant. The CFPA provides broad protection by making it unlawful for any person to engage in deceptive conduct in connection with the sale or advertisement of merchandise, with merchandise specifically defined to include real property. Under ARS Section 44-1522, a violation occurs when a person uses deception, false promises, misrepresentations, or concealment of material facts with the intent that others rely upon such conduct. Importantly, the law does not require proof of actual damages or intent to deceive. It is enough that the conduct was misleading or had the capacity to deceive a reasonable consumer. The statute's broad language ensures that nearly any form of dishonesty in advertising, representation, or omission can constitute a violation. Some of the most common actions constituting violations under the CFPA include false advertising, failure to disclose material facts, bait and switch tactics, concealment of property defects, and false promises regarding the condition, zoning, or income potential of real property. For instance, advertising a property as fully remodeled when only partial cosmetic updates have been made is a misrepresentation. Similarly, failing to disclose known issues, such as plumbing defects, prior flooding, or boundary disputes, constitutes concealment of material facts. Each of these actions creates a false impression that influences consumer decision-making and therefore qualifies as deceptive conduct under ARS Section 44-1522. False advertising is one of the most recognizable forms of consumer fraud. Under Commissioner's Rule R4-2, 8-502, all real estate advertising must be truthful and must not be misleading in any manner. Misstating square footage, exaggerating neighborhood amenities, or digitally altering photos to conceal damage all violate this rule, and by extension, the CFPA, for example. A broker who posts a listing showing lush green lawns and mountain views when the actual property lacks. Both has created a deceptive visual representation. Even minor embellishments in marketing materials can lead to significant liability when they alter the buyer's understanding of the property's true condition. Failure to disclose material facts is another key violation under the CFPA. Concealing or omitting important information that could influence a buyer's decision, such as unpermitted additions, environmental hazards, or prior structural damage, constitutes consumer fraud. The case of Dunlap versus Jimmy GMC of Tucson, Inc., 1984, made clear that omissions are treated the same as affirmative misrepresentations. In real estate, this means a seller or licensee who keeps silent about a known defect violates both the CFPA and ARS Section 32-2153, which prohibits dishonest and fraudulent conduct by licensees. Bait and switch advertising is another practice specifically condemned under the CFPA. This occurs when a business or agent advertises one property or feature at a certain price to attract customers, but then pressures them to consider a different, more expensive property or one with less favorable terms. For example, advertising a home for sale at $299,000 when the seller has no intention of honoring that price is deceptive under ARS Section 44-1522. This tactic not only misleads buyers, but also damages the reputation of the industry as a whole. False promises also fall squarely under the CFPA's prohibitions. A licensee or developer who makes assurances about future events or benefits that are not guaranteed, such as your investment is guaranteed to double, or this subdivision will include a golf course and community center, commits consumer fraud if those promises are untrue or unsubstantiated. Under ARS Section 322153B4, false promises are considered a violation of professional conduct and may result in disciplinary action by the Arizona Department of Real Estate ADRE, in addition to enforcement by the Arizona Attorney General. Concealment of property defects often overlaps with misrepresentation and non-disclosure, but deserves separate emphasis because of its frequency in real estate transactions. A seller who paints over mold damage to hide it, or an agent who discourages inspections to avoid revealing problems, commits a clear act of fraud. Such conduct not only violates ARS Section 44-1522, but also breaches the duty of fair dealing required under R 4-28-1101. Even if the buyer later discovers the defect before closing, the attempt to deceive is sufficient to constitute a violation. The CFPA also applies to deceptive financial representations in investment properties. Misstating rental income, occupancy rates, or operating expenses to induce an investment sale constitutes consumer fraud. For example, presenting a pro forma showing inflated rental income or omitting vacancy history creates a misleading financial picture that violates ARS Section 44-1522. Investors are entitled to accurate and complete information, and deceptive financial advertising falls squarely within the scope of the law. Arizona courts have consistently upheld the broad enforcement of the CFPA. In State Ex Relder Babbitt v. Goodyear Tire and Rubber Company, 1974, the Arizona Supreme Court emphasized that the act should be liberally construed to protect the public. The court ruled that intent to deceive is not a necessary element. What matters is whether the conduct is likely to mislead. Similarly, in Carruthers v. Underhill, 1975, the court reaffirmed that when one party has knowledge of facts not reasonably available to the other, failing to disclose those facts is a violation of both common law and statutory fraud principles. Violations of the CFPA carry serious consequences. The Arizona Attorney General's Office, under ARS Section 44-1524, has the authority to investigate, issue subpoenas, and seek injunctions against violators. The Attorney General may also pursue civil penalties and restitution to compensate victims under ARS Section 44-1528. Additionally, if a violation involves a licensed real estate professional, the ADRE may suspend or revoke the individual's license under ARS Section 32-2153. The cooperation between these two agencies ensures both consumer recovery and professional accountability. Review summary. Actions that constitute violations of the Arizona Consumer Fraud Protection Act include deception, false advertising, concealment of material facts, bait and switch tactics, false promises, and misrepresentation of financial or property conditions. The law applies broadly to all real estate transactions and does not require proof of intent or damages. Under ARS Section 44-1522, any conduct that has the capacity to mislead is sufficient for enforcement. Licensees are also subject to discipline under ARS Section 32-2153 and R4-2-8-1101 for dishonest or misleading practices. Both the Arizona Attorney General's Office and the ADRE play key roles in enforcing compliance, protecting consumers, and maintaining integrity within the real estate industry. Discussion. What is the purpose of prohibiting deceptive conduct even when no financial harm occurs? Answer. The CFPA is preventive in nature, designed to stop deceptive conduct before it results in harm, thereby protecting consumers and preserving market trust. What are examples of action that constitute violations under the CFPA? Answer: false advertising, failure to disclose material facts, bait and switch practices, concealment of defects, and making false promises or exaggerated claims about property or investment performance. How do ADRI regulations complement the CFPA? Answer: the ADRE enforces professional conduct standards under ARS Section 32-2-153 and R4-2 8-1101, ensuring that licensees act with honesty and fairness. Aligning directly with the goals of the CFPA, who investigates and enforces violations of the CFPA? Answer: the Arizona Attorney General's Office, which can issue subpoenas, seek injunctions, and order restitution, often in coordination with the ADRE for licensed professionals. Closing remarks. The Arizona Consumer Fraud Protection Act serves as the foundation for ethical conduct in real estate. By defining and prohibiting deceptive actions, the Act ensures that every buyer, seller, and investor operates in a fair and transparent marketplace. Real estate professionals must remember that compliance is not only a legal requirement, but also a reflection of integrity and professionalism, honesty in advertising, full disclosure, and accuracy in representation. Protect both the public and the reputation of the industry. By understanding and avoiding actions that constitute violations, licensees uphold the highest standards of Arizona real estate practice.